Hello everyone. Welcome to Learn Law with AKP. Today we are beginning Unit 4 of Contracts, namely the Sale of Goods Act 1930. The first topic is Formation of Contract of Sale. Before understanding rights, duties, delivery, or unpaid seller, we must first understand how a valid contract of sale is created. This topic forms the foundation of the entire Sale of Goods Act and it and is frequently asked in semester examinations, law set examinations, and competitive law exams. So, let us begin. Section 4 of the Sale of Goods Act defines a contract of sale. A contract of sale is a contract whereby the seller transfers or agrees to transfer ownership of goods to the buyer for a price. There are three important elements. First, there must be a seller. Second, there must be a buyer. Third, ownership in goods must be transferred for a price. For example, Ram sells his motorcycle to Shyam for 80 lakh rupees. Ram is the seller, Shyam is the buyer. The motorcycle is the goods, 80 lakh is the price. Thus, a valid contract of sale is formed. Now, the essential elements of contract of sale. Every contract of sale requires certain essential elements. First, there must be two distinct parties. Second, there must be goods. Third, ownership in the goods must be transferred. Fourth, consideration must be in the form of money called price. Fifth, all essentials of a valid contract under the Indian Contract Act must be satisfied. Without these elements, a valid contract of sale cannot exist. Now, a contract of sale requires two separate persons. One person must sell and another person must buy. The same individual cannot simultaneously become both seller and buyer of the same goods. Example, a shopkeeper sells a mobile phone to a customer. The shopkeeper acts as seller. The customer acts as buyer. Thus, two distinct parties exist. Now, the subject matter of a contract of sale must be goods. Goods generally mean movable property. For examples, cars, books, computers, furniture, mobile phones. However, land and buildings are not goods because they are immovable property. Therefore, the Sale of Goods Act applies only to movable property. Now, the most important feature of a sale is transfer of ownership. Ownership means legal title over goods. In a contract of sale, ownership moves from seller to buyer. For example, Ram sells his laptop to Shyam. After completion of sale, Ram no longer owns the laptop. Ownership now belongs to Shyam. This transfer distinguishes sale from other transactions like bailment or lease. Now, the consideration in a contract of a sale must be money. The Act specifically uses the word price. For example, a car sold for 5 lakh is a contract of sale. However, if a car is exchanged for another car, it becomes barter and not sale. Thus, money consideration is essential. In section 4 recognizes two forms of contract of sale. First is sale, second is agreement to sell. In sale, ownership transfers immediately. In agreement to sell, ownership will transfer at a future date or upon fulfillment of certain conditions. This distinction is extremely important for examinations. Now, let us understand the difference. In a sale, ownership transfers immediately. The buyer becomes the owner at once. In an agreement to sell, ownership remains with the seller until future conditions are fulfilled. For example, if a car is delivered and ownership passes today, it is a sale. If ownership will pass after full payment next month, it is an agreement to sell. Now let us study an important case law. In Rowland vs. Divall, a person purchased a car believing the seller had valid ownership. Later, it was discovered that the seller had no legal title to the car. The true owner reclaimed the vehicle. The buyer lost possession and sought recovery of the purchase price. The court held that since ownership had never validly passed, the buyer was entitled to recover the entire price. Here, the principle established is a seller must have a valid right to transfer ownership. This case highlights the importance of transfer of title in a contract of sale. Now, let us summarize through an example. Ram sells a bike to Shyam for 80,000 rupees. Ram is the seller. Shyam is the buyer. The bike is the goods. 80,000 is a price. Ownership passes from Ram to Shyam. Therefore, all elements of a valid contract of sale are satisfied. Let us quickly revise. A contract of sale requires seller, buyer, goods, transfer of ownership, price in money, and a valid contract. Remember these 6 essentials carefully. Now, let us conclude today's topic. A contract of sale is defined under Section 4 of the Sale of Goods Act 1930. It involves transfer of ownership of goods from seller to buyer for a price. We also learned the essential elements of a valid sale and the distinction between sale and agreement to sell. We further studied the important case law of Rowland vs. Divall. Therefore, formation of contract of sale is the foundation of the Sale of Goods Act. For examination, always remember definition, essentials, differences, examples, and case law. Thank you for watching. If you found this video helpful, please like, share, and subscribe to Learn Law with AKP. See you in the next class.